the Texas, I've even forgotten now, the TCPA, Citizens Participation Act. The first question then, under these kinds of cases, of course, is whether or not the TCPA applies to the communications which form the basis for the plaintiff's claims.
Question about the plaintiff's claim.
Sure.
It's been a bit since I've read the briefs, but it sticks in my mind somehow that maybe the motion to dismiss from TCPA did not encompass all the causes of action alleged. Am I wrong on that, or is that?
No, you're correct. What happened was that Mr. Templin filed the initial petition, which alleged, based on the letters, and you should have handouts which include those two letters that are in question. Mr. Templin alleged defamation, intentional infliction of emotional distress, etc., claims arising from those letters. So we filed a motion to dismiss under the TCPA. A few months later, the plaintiff amended their petition. They changed, they reframed their allegations a little bit. Before, they had framed the allegations on the basis that the letters falsely and defamatorily alleged that Mr. Judge was unable to practice law and had a disability. With their first amendment petition, they changed that a little bit to where the nature of their claim arising out of the letters was, they said, based upon the implication that Mr. Judge was no longer practicing law. Of course, for TCPA purposes, it doesn't really matter that they amended their petition, but we're here about the claims involved now. But in the amended petition, they also added some claims. Declaratory judgment, for example, accounting, and several breach of fiduciary duty claims. Most of those, with the exception I'll tell you about in just a minute, most of those are not part of the TCPA because they're not based upon these two letters that you have in front of you. Now, there is an issue that you will see in the record and in the briefing regarding a subset of the breach of fiduciary duty claims. I believe there's 3 that are expressly based upon these letters. And so we, after the amended petition was filed on September 2nd, 2020, we amended our pleadings on September 9th, 2020, as well as adding a reply on the same day to the response of the plaintiff to our motion to dismiss, which was also filed on the 2nd. So a week later, we filed our amended answer. We filed a reply to their response, in which in both of those, the pleading and the reply, we very specifically and expressly attacked those 3 subparts of the breach of fiduciary duty allegations, saying that those were part of the motion to dismiss. So the judge ended up ruling that we had not attacked those with our motion. And so she did not address those. She said they're held. But they were in fact there. We did in fact do that, and we cited in the brief, and I can cite to you here if that's important to you. I can cite the record where those are. In any event, those things are where before you. Regardless of what happens here, there'll still be a lawsuit later on.
And I guess that was part of my question.
Right.
And the other thing, I guess I know the answer to this too. There was no motion for summary judgment filed on those causes of action that are outside of the TCPA at this time that you're asking us to review or anything.
That is correct. That hadn't been filed yet. But those are all those causes of action are controlled by the company agreement. And actually that kind of goes to Mr. Judge's claims of damages, because he actually claims that he was damaged by these actions because he didn't get his fee from his clients, which they aren't his clients and they aren't his fee. It's a law firm, Judge Kostura and Company, PC, that has the clients, that has the contingent fee agreements, that earns the fees, and that then, according to their company agreement, distributes profits. And so,
Let me ask you a question along the TCPA lines on that. Let's take a slightly different set of facts. Suppose that rather than during this period of absence, Mr. Judge says he's going to sail the world for a couple months, and your clients use that as the opportunity to send out a letter that says, while Mr. Judge is incarcerated, I mean, clearly a false statement that imputes he's done something wrong. Does TCPA still apply there as well?
Yes, I believe it does. Now, I mean, that's a different set of facts.
Right.
So it's a lot easier to show that that was a false statement, which we don't have here. And so it's pretty easy for him to file prima facie evidence to show that to be the case. But here, I mean, this is a completely different case where that's not what happened, and he wasn't able to apply.
If the letter had simply said, Mr. Judge is absent and it doesn't make any statements about his fitness to practice law or any implications, do we have a matter of public concern that would invoke the TCPA there?
Actually, you do. And the reason is because it's an attorney communication with their clients. And everything changes when you have an attorney communication.
Attorney communication, and we were kind of talking about this yesterday. Attorney communication with your client only private.
Correct. They're privileged. That's right.
What makes it of public concern now in this situation, if it's normally privileged and private?
Right. And understand that that's a different analysis and that's a whole different thing, is whether or not that communication can be disclosed. Here, since we had the attorneys, that this was a suit by one attorney against two of the other attorneys in the firm, that's just not implicated. But we do have attorney immunity.
I understand.
And some authorities call that an attorney privilege, but they're the same thing. And that has to do with the freedom of an attorney to communicate. Now, why that becomes a public concern is because of the nature of an attorney-client relationship. For example, the preamble of the Texas Disciplinary Rules of Professional Conduct say that conferring a license to practice law transfigures attorneys from private citizens into public citizens with a mandate to keep the clients informed. That is in the preamble of the disciplinary rules. The disciplinary rules go on and on about the kinds of things that are required. For example, the Texas Supreme Court has recognized that in the Lippincott case. The Supreme Court ruled that private disparaging remarks about that was a different one. I'll get to that one in a minute. The disciplinary rules of professional conduct also say, and I'm quoting here, the legal profession has a responsibility to assure that its regulation is undertaken in the public interest and insist that every lawyer both comply with its minimum disciplinary standards and aid in securing their observance by other lawyers. Neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. Lawyers are regulated by the state law, their behavior, including their behavior with clients and their behavior with each other. They're regulated by the Supreme Court. And it's because we operate for the benefit of the public.
The relationship.
That's right.
It's ended to the clients.
Right. And maintaining here,
Their purpose, I guess.
that's right. And here it becomes even more so because the communications in question deal with clients who have active or proposed judicial or governmental proceedings. They weren't all court situations. There were employment cases, so we're dealing with EEOC as well. But in those contexts, that makes it a matter of public concern. Do
you have any authority where anybody else has held in the past that something is a matter of public concern, even though it's a private communication that's only intended
Yes, sir.
within that context?
The Texas Supreme Court, and that was the case I stumbled on a minute ago, the Lippincott case, which was not a lawyer case. That was a CRNA case, where there were some communications amongst physicians. And like this one physician said, "You libeled me in your private communication." And the Texas Supreme Court ruled that private disparaging remarks about a CRNA's qualifications, fitness, and behavior with patients constitutes a communication related to a matter of public concern.
Did this court address that in Batra? What's the code now? No? The call?
I can't remember, Judge.
That's one.
I can't remember. Now, the statute itself also is pretty broad. It defines a matter of public concern, meaning a statement or activity regarding, among other things, a matter of other interest to the community or a subject of concern to the public. And fitness of an attorney to represent clients in a diligent and competent manner is a matter of public concern. And so, yes, we do have public concern. Mr. Judge pleaded that very thing too. He pleaded and testified in his affidavits that the letters that we put before you here are related to the quality of his legal services. He says in his original petition, although limited in publication, defendant's publication was reasonably calculated to result in repetition into the public domain beyond the media in which it was communicated. He also then, in his pleadings associated with the motion to dismiss and his affidavit, said that the communications specifically related to judge's health and his ability to practice law and continue practicing law. Now, he's claimed that his fitness and ability to practice law was, quote, was a private matter between me and my clients. Well, that's factually and legally wrong. It wasn't just a private matter between he and his clients. It also dealt with the firm. It also dealt with the other lawyers. And of course, since he's a lawyer licensed by the state of Texas, he's also involved with regulation by the Texas Supreme Court and the state bar, making it a matter of public concern. And both the Lippin Court, Texas Supreme Court and Lippin Court, and the Angeles, now that's a lawyer case, that the Angeles case held that private communications involving lawyers are matters of public concern. And more to the question you asked earlier, Justice Doss, another case in Texas, the Angeles case, said public or private communications related to the provision of legal services to the public by licensed attorneys are recognized as matters of public concern implicating the exercise of free speech under the TCPA. So, yes, this is a matter of public concern, even though it is a private communication.
In the Angeles case, who was the statement underlying the claim mentioned? Was it mentioned to a client, or was it mentioned publicly in general?
It was
I
mentioned.
haven't read the case, so I haven't read it.
Yeah, and I've read so many, I'll stumble over which set of facts they are without looking at. I'll look at that and tell you in my rebuttal exactly what that was. I believe though it was a client, but I'll look and confirm. So it is a matter of public concern. Clearly a matter of free speech. There's no contest that it's a communication. It implicates the right to petition because these clients had active or prospective judicial or governmental proceedings. It implicates the right to associate because the attorneys advise the clients about another licensed attorney's ability to fitness to practice law is a situation where the lawyers and the clients join together to collectively pursue or defend common interests relating to a governmental proceeding or matter of public concern as defined by the statute.
You mentioned it's free speech, right, about commercial.
Yeah, let's talk about commercial. Because really that's what this case comes down to. is the commercial speech exemption. Okay, and here, the commercial speech, this speech is not commercial speech. Now, the plaintiff wants to go through and take down the four technical elements, but Castleman, the Texas Supreme Court in Castleman, has told us that you can't just rely on that. You have to read the content and context of the communication itself to see if it really is commercial speech. This is the Supreme Court. Thus, the commercial speech exemption applies only to certain, they highlighted certain communications related to a good product or service in the marketplace. Communications made not as a protected exercise of free speech by an individual, but as commercial speech which does no more than propose a commercial transaction. Okay? And here, that's what we've got. And I want to particularly bring the court's attention to the Tahiri case out of California. That there is the one case out there construing the commercial speech exemption, which deals with an attorney communication like what we have, as opposed to attorney solicitations. There's some cases out there, Miller Wise brought a recent case, Busby, where the communications in question are clearly solicitations. And under those circumstances, yeah, they fall under the commercial speech exemption.
We have at least one letter that's made construed as solicitation.
No, if you look at it, what that one says, it doesn't solicit the business. First, you got to understand that the clients were already clients of Judge Kostura and Putnam. And when you look at that letter, what that letter says is, John Judge is no longer with our firm. It expresses their concern that his medical issues and his ability to return to the practice of law may continue into the future. And then it says, you can retain Mr. Judge. Oh, it says he's out of the firm now. You can retain Mr. Judge. You can retain us, or you can retain somebody else. And that's what it says. And you know, what's interesting is if you look at the language and be careful about the language, it says, if you care to retain us, we can do that. What does retain mean? I looked it up. Definition of retain means to keep or to hold. They were already their lawyers and said, if you want to retain us, you can. But there's no solicitation in that letter. That letter cannot be read as a solicitation. And besides, as we pointed out in the brief, and I won't waste any time over
It says, if you prefer for us to handle your case, you may retain us.
right, keep us.
That's okay. It says, if you prefer to retain new counsel outside either our firms, you may do that. Well, if retain means keep, it doesn't follow in that sense. If you prefer to retain new counsel outside either firm. They go to a new firm, you can't keep because they haven't had.
And my point is, Judge, that this word has multiple meanings.
That's
And so
exactly
you
right.
can't exclude the other meaning. And actually, it does mean that in this circumstance because the firm has already been retained. They've been hired, signed a contingent fee agreement, etc. And so they say, if you want to retain us, that's fine. If you want to retain John Judge, here's his contact information. If you want to retain somebody else, just let us know when we can file. That is not a solicitation. And that's not proposing a commercial transaction. That's advising a lawyer that Mr. Judge is no longer with the firm and that these lawyers have concern about his health and ability to continue to practice the law for the foreseeable future.
I have one brief question for
Yes,
you. It appears from the language of the order that the language denied the motion to dismiss specifically because of the commercial speech exception.
right.
If we disagree with that, is it still necessary to remand for the TCPA analysis?
No, because this is a de novo review. And so you look at the motion under a de novo review, and everything is a question of law under de novo review.
So
So,
the novo review of the decision and grounds uttered by the trial court, is it a de novo review of everything?
I believe it's a de novo review of everything. So this court has the power to review the motion to dismiss. And if the motion to dismiss is proper, or the denial was improper, then this court has the power to dismiss the case.
Compared to a summary judgment.
Right, which is different.
Multiple. TCPA, the Supreme Court tends to think that TCPA is kind of like a summary judgment. But in a summary judgment, multiple grounds, the court specifies the one and says on X ground, granting summary judgment case now. We review just that one ground on summary judgment, or we review all the potential grounds?
In summary judgment, you can affirm on any ground. Now, it comes up in a little different circumstance because of the factual nature, and instead of just showing that motion to dismiss is more of a pleading base, even though one party has an obligation to show prima facie evidence, and another party, if they can, which we did, show a reason as a matter of law, which is attorney immunity. But anything that is not challenged in the record and preserved, you guys can move right on over in a motion for summary judgment. Now, that's a question of, that really falls on us, the practitioner, to make sure that that's preserved.
Thank you, sir.
May it please the court and counsel, I really need to replace that, but let me just begin by saying a couple of things. As the court's well aware, there's been as much authority for TCPA on this court probably as any court in the state. It's been well written about.
But it seems like if I write on it, I'm wrong. Which included Castleman and reliance on the California statute, so.
So, now one thing I would point out that the TCPA was substantially amended, pretty substantially amended 2 years ago in 2019. And one of the biggest changes that was made, the commentators have pointed this out, was the definition of what constitutes a matter of public interest. And so I'm not saying that the cases before that amendment are of no value. I think they're of value, but I think the court has to be careful using precedent before the statute was changed. So we have that.
We still have the language on the statute that defines matter of public concern as a statement or activity regarding a subject of concern to the public.
Yes. And the Supreme Court addressed that right before the statute was amended. So it's based on the old statute that says it doesn't relate to a matter that's purely a private concern to the parties involved. And so I'll get into that. I wanted to address, and as the court's aware, in this case, the court's written this a number of times, it's a three-step process. But basically, first thing is you determine whether the TCPA even applies. The second part is if it does apply, then the court considers whether there's an exemption, in this case, the commercial speech exemption. And then if the court says it's covered, there's no exemption, and so it's still covered, then we get to part 3, which says, did the plaintiff present prima facie evidence, clear and specific evidence of a prima facie case? And so it's that three-step process. We believe, and the trial court's order that reflects that in the trial court's case, the consideration began and ended with the commercial speech exception because it's a clear, in our view, a clear application. So I'm going to try to address all of those phases a bit in the limited time that I have, but I want to talk about the facts for just 1 minute. And the appellant has presented the facts in one way, but here's what the evidence shows. And that is, Mr. Judge he had really reached rock bottom in his life. There's no question about that. He had developed a pretty significant alcohol dependency problem. And he was in a situation in 2020, about a little over a year ago, where he was not really capable of practice law for the time that he himself went to an alcohol treatment facility. He participated in the program. At the end of the program, which occurred at the end of April, he received a release from the program to return to full duty with no restrictions. So and certainly at that time, Kostura and Putnam had every right to get Judge out of the firm. Now, there was another motive here, and that was there was a multi-million-dollar case that they had been working on, a contingent fee case that was about to settle, was just on the edge of settling, and they wanted to keep him from getting his share of that fee. But if they wanted him out of the firm, there were three ways they could do it. One, they could go to him and say, look, we want to be separated, let's work out an arrangement. They didn't ever do that.
So what is the case you just referred to, is that call, Bob called that in his letter of June 12th, 2020?
It may be.
Is that?
No, it's not that case. It's another case. So no, it's not that case. They could have worked out something, but he owned 1/3 of the corporation. He was a founding member of the corporation. They never wanted to pay him anything for his interest or give him any interest in the accounts receivable. And they just wanted him out of the firm, just back out. So they kept saying over and over, either retire or go out as a sole practitioner. And his view was, well, I still own 1/3 of this firm. I'm entitled to my share of the 1/3 firm. So there was two ways they could, if he wouldn't agree to get him out. One was to dissolve the corporation. It was a PC. The other was to declare him incompetent or incapacitated. But then there was a provision in the agreement to buy him out of his interest and basically to compensate him for everything. Well, they didn't want to do that. And so what they did was kind of a hybrid. They declared him incapacitated to practice law or disability to practice law. But they never made any attempt to compensate him in any way for his interest. They were just trying to force him out of there.
You could still litigate those issues and not implicate the TCPA under your breach of fiduciary duty claim, though, right?
Yes. So those issues are separate. Okay. So we get down to the letters, and the context of the letters is that on May 29th of last year, 2020, which was the Friday before the Memorial Day weekend, Mr. Judge finally hires Ms. Templeton as a lawyer. And Ms. Templeton sends a letter because they had shut Judge out of the office. Of course, the office was closed because of COVID, but they had shut him out of his computer files. They had basically stopped him from practicing law. And so Mr. Templeton writes this letter where he says, my first request is that you immediately allow Judge to access his computer. As you know, he is still practicing law. So they're told about 5 p.m. is when this, or in the afternoon of Friday, they said, Templeton says to Putnam and Kostura, he's still practicing law, but he needs access to his files. But then he said, well, we can talk about the issues between these parties. And he gave him his cell phone number so that they could contact him over that holiday weekend if necessary. He understood, I think everybody understood, that there was some urgency to this situation. And so that was Friday. Now, right after he sent that letter by email, he got a response back, and they acknowledged receipt of the email and stated that they shared Mr. Templeton's hope for a smooth transition and are glad Judge has someone to help him in this process. We look forward to discussing these issues with you. Now, the implication that would lead to a reasonable person is we're going to talk about this. We're going to work out something here. Well, that was Friday afternoon, after 5 o'clock. And so Monday's a holiday. Early Tuesday morning, they start sending out all these letters to Judge's clients. And the letter is artfully written by a lawyer, obviously. And it speaks of their opinion, but what it says is that while we hoped he would be able to return to the practice of law, it is our personal opinion that he is not able to do so now, and that his disability may continue into the foreseeable future. They send that letter to in groups to all of Judge's clients. Now, they had no business. That was a very vindictive and hateful act to do that, to communicate directly with clients that they had not represented, that he had represented, and to tell them something that was false. The letter conveys no implication other than the fact that the judge had ceased practicing law and would not be returning anytime soon. So, as it turned out, all of Judge's clients, except for one, came back to Judge. When they got this letter, they called Judge and said, "What's the matter? You've been representing us?" We had no idea. He was able to get his clients back except for one kind of significant file. But what makes this so egregious is, so they didn't send to all of Judge's clients at once, just a few. So Templeton, when the judge gets the first call from a client saying, what's the deal with this? So Judge gets a copy of the letter, and so Templeton emails the defendant and says, I said, I have a copy of your letter to such and such a client, and I request that you immediately send me a list of all clients who received that letter. It is incomprehensible to me that you would take this action, which is obviously a blatant attempt to take John's clients. I need your firm's general ledger information and so forth. And so what do they do when they get that letter? They send letters to more of Judge's clients, the same letters. And so he sends them another letter 2 days later and says, you're still doing this. I demand that you retract these allegations. And what do? They send more letters. So in 3 groups, they send these letters out to every one of Judge's clients. It caused a lot of confusion and a lot of problems. Now, the one client that they basically, which we think they solicited and that did in fact leave, was on the verge of settling. It did settle and earned a significant fee. And of course, it was never accounted to Judge for the time that he had put in on that case.
Was that the subject of the letter? Or
Yes.
was that somebody else?
No, that was the final letter that was sent on June 12th, and I believe it's the last letter that we have a copy of here.
Well, I think that's what the chief was asking a moment ago.
The Coleman case. That's there was another contingent fee case that was significantly larger. It was a multi-million-dollar case. This one was probably less than 100,000, but it was a contingent fee case that generated a significant fee. So there were ways they could have gotten out. Now, if they've honestly felt or had reason to believe that Mr. Judge was disabled from the practice of law, the proper procedure on that is to go to the state bar. I mean, there's a procedure in place to go to the bar and ask the bar to intervene, but you don't just call off and send letters to a lawyer's clients. And what makes this even more egregious is the fact they didn't copy Judge on this letter or his lawyer. They just sent them out. They didn't even tell them they were going to send those letters Tuesday morning. They just sent them out.
To the extent they could go to the state bar and be because they believe he was no longer able to practice law, not practice law. Does that indicate there's a matter of public concern?
No, it's still a very private matter. You know, if a lawyer is having mental issues or physical issues that make that lawyer incapacitated, it's even like with a lot of ethics issues, a lot of ethics complaints are private matters, basically, until they reach a certain point. Otherwise, they can destroy someone's career.
But the ability, that even in an ethics situation, first level is they don't say who culprit was, so to speak. But the state has an interest in assuring that the public is adequately represented. We won't mention who the attorney is, but we want to make sure we take a step to discipline that attorney somehow.
Yeah, in a disciplinary procedure.
So even though they're not disclosing names and identities, they have sufficient interest to say we're going to intervene because it's important.
Yeah, it's a professional issue, yes.
Why would that also apply in the TCPA with regard to matter of public concern? We're not going to necessarily say we'll disclose who that person is, but the ability to regulate attorneys and their competence, et cetera, is the issue of public concern.
Or maybe sometimes we do. You look at the back of a Texas bar journal, it's a list of attorneys and misconduct by law.
And when you got to second step, yes, but that's what I'm trying to announce out to the TCPA.
Well, and I think that's a good point, but still, this is basically a matter between judge and his clients, whether he's going to continue representing them or not. And so it's a purely transactional matter limited to this transaction. Let me talk for just a moment about the commercial speech exception, because as I said, that's where the court conducted its
Can I ask you a preliminary question?
Sure.
Is it to get to the analysis under the commercial speech doctrine, we're talking about a three-step process that we look at in TCPA. It's necessary first that we make the determination that the TCPA applies.
Well,
Right.
obviously, the commercial speech exemption doesn't apply unless the TCPA applies. Okay. But there are cases, appellate cases, where they say, we're just going to go straight to the commercial speech exception. And if it clearly applies, we're not even going to. So it just depends.
Well, and I guess that's the question I was asking Mr. Lovell just a minute ago was, if we don't agree with the trial court, the commercial speech exception applies, do we have to remand on the TCPA's application? Or is that something that we can say, well, obviously all the parties agree the TCPA applies because you wouldn't have argued the commercial speech exception otherwise?
No, we made the commercial speech exemption. If we said, in the trial court and in the appellate court, first of all, TCPA doesn't apply. But if it did, we're exempt under the commercial speech exemption. Now, whether this court would imply that the trial court found first that the TCPA applied, I don't know. I mean, there's nothing on the record that indicates that.
It's just not on commercial.
Yes. Yes.
Given that you mentioned cases that they're saying, yeah, we understand it's three-step, let's just jump to commercial speech. Can we necessarily imply that the trial court went through the 3 steps and didn't just jump to the commercial speech?
I don't think you can imply that because nothing in the record indicates that.
So if we were to say, okay, commercial free speech doesn't apply, and we negate the basis the trial court acted, express basis, we send it back to the trial court to consider the rest of it.
That's an interesting question, and I don't know of any authority on that, because this is an interesting case, because the trial court order didn't just say denied, it said denied under the commercial speech exemption. And that's analogous, I think, to a summary judgment where the court just grants it on one ground. And so there's no indication in the record that the court ever considered steps 1 and 3, and so that's the determination this court would have to make, is whether, in fairness, you send it back to the trial court to rule on those. So, now let me talk about the commercial speech. Y'all, I don't bring any easy cases to you.
You don't.
So, let me
Neither of you do, so we're not going to discriminate.
Well, and we could compound this one. We could throw rocks at the legislature for this one.
Well, I
So
think there's some rocks that need to be thrown. So we've got the commercial speech exception in the Castleman case, the court basically said there's 4 requirements. And it's clear, we covered this in our brief, but each of those 4 are literally and fully met in this case, and not just by some evidence, by evidence from the defendant's own affidavit testimony. Number 1, the defendant was primarily engaged in the business of selling goods or services. The Schimmel case that we cited says that legal services are services for purposes of TCPA, and Kostura's affidavit admits at all times, working this litigation, I was practicing law through as an officer or director of JKP. We have similar testimony from District 5. The number 2 element is the defendant made the statement or engaged in the conduct on which the claim is based in the defendant's capacity as a seller of those services. And they, once again, they allege in their pleading each act undertaken by defendants was performed in their capacity as attorney members of JKP for the representation of clients of the law firm. That's the position they staked out, and so they're bound to that position, whether we argue about it or not. Number 3, the statement or conduct at issue must arise out of a commercial transaction involving the kinds of good services that the defendant provides. Well, these communications arose out of the very services they said they were providing at the time, according to their own affidavit. Kostura said in her affidavit, each of the June 2020 letters was addressed and delivered to clients of JKP. Each letter gave legal advice to a JKP client regarding a pending legal matter for which the attorney's firms had been hired. Each letter was from the representing law firm to the client regarding the case matter.
Right there. The two remaining partners said, we do not practice in the area Mr. Judge practices, so we provide those services. Do you look, to answer that question, do you look at just those two attorneys, or do you look at the law firm?
They said in their pleadings, everything we did was on behalf of the law firm. Okay, they're trying to avoid personal liability. So they said everything we did was on behalf of the law firm. Well, those were clients of the firm at the time. That's the position they take.
And the firm did provide those services.
Was providing those services, and they're saying we were providing those services when we wrote the letter. Now, we disagree with that, but they've taken that position, so they're bound to it. And the final thing is the intended audience of the statement of conduct consisted of actual or potential customers of defendant for the kinds of goods or services defendant provides. Now, there's no question that that is the exact case here. These were actual customers, and in one case, it was initially a potential customer. And so there's no question that number four. Now, what they try to do is add language to the Castleman case that says you have to propose a transaction, but the cases that have been decided by the Court of Appeals, and the Supreme Court never said that. It described the four elements you've got to. One other word I might want to add in the short time I have, the Talheri case out of California, we think is distinguishable for three reasons. One, factually, it's distinguishable because in that case, the client actually went to a lawyer to seek legal advice. That wasn't the case here. And this wasn't legal advice. This was medical advice. In our opinion, he is going to be disabled. The second thing is the California business commercial speech exemption is significantly different from Texas. We rejected the Texas model the California model when the Texas commercial speech was written. And the third thing is that the California Supreme Court did what it often does. It says if we were to apply the statute as written, the plaintiff is right, but we're not going to apply it literally. So they view themselves as many times as a super legislative branch of government, which has never really been the case here in Texas. So I'm out of time. Any other questions?
Thank you, Counsel.
Thank you.
First, the Angeles case that I mentioned before, that was the Rule 202 petition case involving the advice. Now, with respect to Tahiri and this court's justifiable concern and perhaps scar tissue of the Castleman case, and relying upon California authority.
Let me have to distinguish California authority saying really didn't apply. The Supreme Court said Queen. When they say Queen, but they said no, that's wrong. But anyway.
But here, of course, we have a different circumstance. And since then, as mentioned, the statute has been amended. And in the legislative history of that amendment, the senator who proposed and sponsored that amendment specifically said that this statute in Texas generally follows the California statute, and the California statute and the interpretations in California present a good model for Texas because they've had it longer and they've been able to see different circumstances. And what we have here is now we have two cases in this country where we have a similar concern about lawyers fighting one another about what one lawyer told a client. Okay, two cases, this one and Tahiri. And Tahiri analyzed the commercial speech exception, which is not identical but for all intents and purposes, it's the same. And I quote, construing the commercial speech exemption to encompass a cause of action arising from advice given by a lawyer on a pending legal matter would serve to thwart the client's fundamental right of access to the courts and specifically to the lawyer of his choice. The client's right to receive legal advice relating to his representation and to change lawyers if he chooses would be thwarted if we were to construe the commercial speech exemption to apply to lawyers providing legal advice, even if that advice includes an element of commercial speech.
Doesn't that implicate what you just read, implicate what Mr. Smithy said as a final reason for distinguishing California? And I guess that's the Curry case, whatever.
That Tahiri, yes, sir.
That suggests it can be read as saying, it doesn't really matter what the words of the statute say. We're not going to apply it because we have these other interests out here that supersede and those interests, you know, the relationship between attorney and client, et cetera, et cetera. Do we follow what the words say, or do we look at the other interests that the California court said should be considered?
You need to consider what California courts say. And one of the main reasons is because of what the Texas statute says. And the Texas statute says this chapter does not abrogate or lessen any other defenses, remedy, immunity, or privilege available under other constitutional, statutory case, or common law or rule provisions, and is to be construed liberally to effectuate its purpose and intent fully. And so what they're asking you to do, what Mr. Judge is asking you to do, is to construe the statute so as to, at a minimum, lessen the attorney immunity. Tahiri looks at attorney immunity. Attorney immunity answers this whole case. Because if it's a legal advice, it is not commercial speech. And as the Castleman Texas Supreme Court case said, you have to look at the content and context of the speech to see if it is more than proposing a commercial transaction. This is more than proposing a commercial transaction. This is advice. Who else but a lawyer can give their clients advice on whether or not one of the lawyers working on the case is fit to do so, and whether or not the client needs to get other lawyers?
Why shouldn't we look at attorney immunity and under the fourth step or whatever, the one that says are there any defenses,
You
as
can't.
opposed to melding it with commercial speech?
You don't have to, because, I mean, you can go all the way to the end, but you don't have to, because attorney immunity also goes right to the heart of the commercial speech exemption. Does that exempt here's what it really comes down to. The fact that the lawyer has an arrangement with the client to be paid for their advice, that, according to Mr. Judge, that automatically makes it commercial speech, period. Because anything that lawyer says in giving advice arises out of that arrangement because the lawyers and the client agreed that the lawyer would be paid. And so they want to blanket all of those communications with the commercial speech exemption. And that's not what the statute is intended to do. And it tells us that. And Castleman tells us that. And Tahiri tells us that.
I can't remember, did you raise attorney immunity as a part of your TCPA motion? Or was it somewhere, okay. Because the court denied on those other grounds, how do we know if the court ever addressed your issue on attorney immunity? I guess I'm kind of getting back into the remand issue here.
I understand that. And yes, her order did not specify any rulings on these other aspects.
Well, it would serve as a denial of it, wouldn't it? Because if she'd agreed with you that it was immune, then there would be nothing there would be no commercial speech doctrine that would keep the case going forward. That's what I'm
She
trying to
agreed
determine.
with what we're saying, that attorney speech to a client is not commercial speech, at least in this context.
I know.
You're correct.
Within the context of the TCPA. I
Yes,
guess I know
sir,
what you're
you're
saying.
correct. And
But not with regard to, as the chief was asking the question about attorney immunity being an affirmative defense. That's something we address later on down the road.
right, but whether or not it is actually commercial speech, that is on the front end.
Did you argue that in your motion? I haven't read the motion, but did you argue in your motion that attorney immunity, did you know attorney immunity and commercial free speech in your motion as opposed to just allege it as a defense?
So we did argue it as part of the upfront.
Commercial free speech.
I don't know that we got into, we argued it as to whether or not the TCPA applies, okay, which encompasses the exemption.
Right.
Any more questions? Okay,
Aren't
thank
you
you.
tired of them?
No other questions. Thank you.
Thank you.
And thank you for the opportunity to stand up in a courtroom.
Anytime. The case is submitted and you're free to go, and we will be in recess. Thank you for showing up and in person. Hopefully we'll do this one.